Thanks for joining us at Thandeka Mpanza to discuss two labour law matters this morning. Let's maybe start with the one dealing with unfair discrimination related to the appointment of foreigners as employees. There was a court case about that, and the argument was raised that that amounts to discrimination against South African potential employees. Is that right?
That is correct, Volker. Well, firstly, good day to you and good day to the listeners at home. So primarily, what happened in this matter is that for the benefit of our viewers and listeners who might not know the company called Mukuru. Mukuru is a company that primarily facilitates the transfer of funds between foreign nationals in South Africa to their respective home countries. So this matter, we found ourselves in a situation where Mukuru wished to apply for a foreign visa, which basically is a visa that would allow them to employ foreign nationals in South Africa. So when they approached the Department of Home Affairs with this request, the Department of Home Affairs was not satisfied that they had done enough to try and employ foreign South African nationals within the country, and they requested that they approach the Department of Labour with a certificate confirming that despite a diligent search that they cannot find suitably qualified South Africans to conduct the work of what foreign nationals would do within the company. And primarily that is where the whole dispute started, and the matter was then brought before court.
Okay, and the court had to decide, was this discrimination or not by the employer, and then what was the finding?
So before we go into the finding, I think it's important to look at the considerations that were before court. Now, primarily, Mukuru argued that their operational requirements require that they hire foreign nationals. The primary reason being is that they say that because they service foreign nationals within the SADC area, they would, to offer better service rendering to their clients, they would require some foreign nationals to be the ones who are employed by them.
Because of the language issues.
Because of the language barrier, indeed, so forth. However, the Department of Labour disputed, said that no, but your operational requirements are mainly technologically based. It's very few instances where only when you're dealing with complaints and the likes that you would actually need somebody who's fluent in the languages of those other countries for them.
Yes.
So the court had to weigh those considerations, and the court did concede that yes, indeed, to a certain extent, Kuru does require foreign nationals to execute their duties. However, it's not primary, it's not core to the operations of the business, and they can therefore proceed to hire South African nationals, or at least train them enough to be able to facilitate those duties. And therefore, the court decided that it was indeed the actions of Mukuru in hiring foreign nationals solely within the company amounted to unfair discrimination, and it adversely impacted the rights of South African labourers. Another important consideration that the court took into consideration was that they looked into the Immigration Act. Now, the preamble of the Immigration Act said that while primarily the objectives of the Immigration Act is to advance foreign employment in South Africa, however, that should not adversely impact the rights of the South African labour force. And that is primarily what the court relied on, as well as the constitutional right to not unfair labour practices and the right to equality and so on. So the court did find that Mukuru acted, or the actions of Mukuru amounted to unfair discrimination against South African labourers.
All right, interesting. So the court didn't accept Makuru's argument that it had to employ foreigners for those specific positions. It came to the conclusion that they might as well employ, or might as well have employed South Africans to do the job. And constitutional rights played a role in that. The court said you always have the right to equality.
Indeed.
And in this case, that right to equality means that, which is a constitutional right, overrides whatever the Immigration Act might stipulate. So it's one of those cases where the Constitution can be relied on to trump whatever an act stipulates. Would you agree with that? And what would your advice now be to employers? What does this now mean? Can they employ foreigners?
Volker, indeed, I agree with you completely. I think we know that any constitutional value overrides any other rights and so on. And primarily, my advice to employers would be that they need to show the court that they took bona fide efforts into trying to employ the South African labor force and not just rely on the fact that their operational requirements makes it a bit easier if they have somebody, foreign nationals, for example. In this matter, we see that the court remarked that they didn't even make efforts to try and train South African employees, perhaps to teach them
Yes.
the languages and so on. So employers need to really do have more efforts to show that they really tried to train and to employ more South African nationals before primarily excluding them out of the job market.
So I guess it's sort of good news for South African citizens. This case proves that it's not going to be that simple for an employer to convince a court that it had no choice, that it really had to be foreigners that were employed. There would have to be, I guess, very special circumstances, very special skills that are not available in South Africa before you would get away with it.
That is correct.
Okay. Thank you. I think that clarifies that one. Then briefly, maybe we can just touch on another labor law related matter, vaccination and the refusal to vaccinate and employees that were dismissed. There were some reports in that regard as well. Maybe you can just discuss that also.
Yes, Volker, I think if you've been listening to our previous recordings, there have been quite a few cases that came out of the CCMA where employers were said to be justified in dismissing employees who refused to take the vaccination, the vaccine. And in this particular matter, we find that there's a different ruling now where the employer was found to have acted unfairly in dismissing one of the employees who refused to take the vaccination jab. Now, the difficulty that might be with setting a precedent as things stand is that the rulings of the CCMA are not per se binding. So nothing has come before the labor court, and in the absence of anything being confirmed by the labor court, it's basically just leaving a void where we don't know. There's no legal certainty in terms of what is the position with regards to vaccination in the workplace. But primarily that is the judgment that came out of the CCMA. But there are three considerations that we need to look at that employers should perhaps consider when deciding whether to dismiss or retrench an employee who refuses to take a vaccine. The first consideration we need to look at is the Labor Relations Act. Now, in terms of the Labor Relations Act, there are only three instances when you can dismiss an employee. It's either for misconduct, it's either for incapacity due to illness, or whatever the reason may be, and lastly would be a retrenchment in terms of Section 189. So in terms of the Labor Relations Act as it stands, there's no legal certainty with regards to whether a dismissal or whether a refusal to take a vaccine can amount to misconduct or incapacity, and that is the position with regards to the Act. But now there's also the Occupational Safety Act. Now, in terms of this piece of legislation, last year we saw a lot of matters coming before the CCMA where employers dismissed their employees and they placed reliance on this particular legislation. Now, primarily, in summary, what this legislation requires an employer is to create a safe and healthy working environment for the employers, and this may come in the form of requiring the employees to undertake to a mandatory vaccine policy and so on. So that is the legislation that most employers are relying on to enforce the health and safety, to ensure that there's a health and safety working environment in terms of the relevant act. And
obviously, specifically also where there's close contact between, for example, clients of the business and the employees. No?
Yes.
It's a different matter from where the client could maybe work from home. No?
Exactly, and I think that is primarily what why the employee was successful in this particular matter. He argued that his job operational requirements don't require him to be close contact with clients and other colleagues, because he's mainly on the road delivering supplies and so on. And which actually now brings me to the Code of Good Practice, which is an annexure of the Labor Relations Act. Now, the Code of Good Practice was amended last year to incorporate the COVID-19 issues and so on. And primarily what is said is that employers need to look at their job scope, what their job requires. The example that you use is quite correct, that if you are working in an environment where you're in close proximity with clients and colleagues and so on, it might be required that you codify a mandatory vaccine policy and so on. So primarily the lesson would be, or would to employers would be that you need to look, there isn't a one size fits all approach to these issues. You need to look at what works for your company, how your company is structured, and that will pave out a way whether you would require a vaccine mandate, vaccine to be mandatory in the workplace.
All right. Thank you, Thandeka.
Thank you.